You're listening to The Voice of Russia in London, and I'm Daniel Cinna with a discussion on how social networks should be policed. The Director of Public Prosecutions, Keir Starmer, is drawing up guidelines on how prosecutors should react to abusive comments made on sites such as Facebook and Twitter. He says the document will help prosecutors decide whether criminal charges should be brought against people who make offensive comments online. The consultation comes after a series of high-profile cases where social network users have made insulting remarks about the Olympic diver Tom Daley and the footballer Fabrice Muamba. In the last few weeks, Matthew Woods, a 19-year-old man from Lancashire, was jailed for 12 weeks for his Twitter comments about the missing 5-year-old girl, April Jones. So how should prosecutors react to comments made online, and how will the guidelines shape the future of social networking in Britain? Joining me in this discussion is Kirsty Hughes, Chief Executive of the Index on Censorship. Rob Lyons is the Deputy Editor of the online magazine Spiked. Abhijit Pandya is Chairman of the Birkenhead Society, a free speech group. And joining us on the phone is Goodman, a lawyer and chair of the Campaign Against Censorship. We'll begin with you, Kirsty Hughes. Is it time to apply a more common-sense approach to online comments?
I think we certainly do need a more common-sense approach. We've seen some extraordinary and very disturbing prosecutions recently. Barry Thew was recently jailed for comments about police on a T-shirt he was wearing. So this is a lot of this discussion is about online, but it's also offline, and sometimes it's about inappropriate laws for the offline world, or perhaps even for the telecoms world 50 years ago, being applied online. And we've suddenly got this explosion of new technology, new social media, and it's being policed in this excessive way. Rob
Lyons from the online magazine Spiked.
It's really not the place of prosecutors to get involved with comments online, really. If we allow a situation where the authorities are going to determine what should or shouldn't be allowed, then I think that has very serious consequences for freedom of speech. That's not to say that I give the thumbs up to the kinds of comments that have been made. I think Liam Stacey's comments or Matthew Woods' comments have been, I think most people would agree were offensive. But but there's quite a big difference between saying something that is offensive and something that should be a matter of criminal law or even of regulation. At the end of the day, we have to allow for the fact that we need to be thick-skinned enough to accept that sometimes people will say things that offend us online, offline, wherever it is. But allowing people to do that is an important aspect of allowing freedom of speech.
Abhijit Pandya from the Birkenhead Society.
I don't believe that the state should intervene in any of these matters, but the problem we have is we have a framework of law under the European Convention of Human Rights which allows a huge amount of deference for the state to define the boundaries of free speech. Until we get out of a system of the European Convention where the state can define what the boundaries of a particular freedom are, unfortunately the state is going to carry on legislating for those boundaries, and it's going to usurp the right of what is and what isn't permissible to say. And I think that is fundamentally undemocratic. No government or government organ should be able to decide what is or isn't offensive. And ultimately, going back to the history of toleration and free speech, if we started curbing free speech for what was offensive, the Enlightenment wouldn't happen and the modern world wouldn't have been created. So
let's bring in Goodman. We'll come back to that afterwards. He's a lawyer and chair of the Campaign Against Censorship. Edward, what are your comments?
Well, regrettably, with the laws already there, it's the Communications Act 2003, which criminalises grossly offensive electronic messages. And the Crown Prosecution Service are applying this in a very heavy-handed method. There are 340 electronic messages daily, and any complaint they get about one that's offensive, they prosecute. So this is a restriction on freedom of speech. So this act should be amended because it's being used as an instrument of persecution. In America, they're lucky. They've got the First Amendment for free speech, but we have nothing. We've got this Communications Act, which does create this criminal offence of sending grossly offensive electronic messages.
Edward Goodman, how do we define the boundaries of free speech?
Well, the Director of Public Prosecution is going to do some guidelines, but the trouble is you've got this law which says it's criminalised. These victims of these offensive methods could use their own legal proceedings for libel. But here we've got the state prosecuting people in the courts and people sent to prison, and so really I think the Act should be amended to remove the state interference in electronic messages and allow comment, and the victim can take their own legal action if they want to, a civil action for damages and injunction.
Sure. Kirsty Hughes from the Index on Censorship.
I think the challenge of where a society puts the boundaries to free speech is always the big question. And even running a free speech organisation like Index, we would say, for instance, if something is a clear and direct incitement to violence, then there's probably a good reason to have a law that allows you to control that. But here we're a long way from that. We're talking a lot of the time in these prosecutions about things that are offensive to some, to many, to the majority, things that are tasteless. Some of them are jokes, bad and sick jokes, but should we be imprisoning people for bad and sick jokes? And there's also something here about the technology, because if you said some of these things down the pub, you wouldn't get prosecuted. If you publish them in the International Herald Tribune, for instance, then there's certain laws apply for publishing. But we've got this intermediate new technology, and we're applying, as Abhijit and Edward said, old laws and making very bad laws. So we really actually, in a way, I would say we need these interim guidelines that are coming in November. Very glad they're interim, because then there's going to be a consultation to hopefully start to say, stop overreacting, stop taking jokes and offensive comments out of context.
Should people accept that what they say online is not like talking to a friend down the pub? They are publishing these comments online. They're not making offhand remarks in a bar.
I think we're in this new area where it's somewhere between a conversation and publishing. But I don't have to read all these comments. I have tools on Facebook to edit things out. I have tools on Twitter to block things. Now, we can argue about the adequacy of those tools, but a lot of the answer to this is not necessarily using libel laws, it may be occasionally, is how communities self-regulate, how you regulate your own accounts. So we're all publishers, we're all journalists these days, but therefore we're all also editors.
You're listening to The Voice of Russia in London. I'm Daniel Cinna with a discussion on how social networks should be policed. Joining me is Kirsty Hughes, Chief Executive of Index on Censorship. Rob Lyons is the Deputy Editor of the online magazine Spiked. Abhijit Pandya is Chairman of the Birkenhead Society, a free speech group. And joining us on the phone is Edward Goodman, a lawyer and chair of the Campaign Against Censorship. Let's bring in Abhijit Pandya, chair of the Birkenhead Society. What are your thoughts about defining this line where people might need to accept that what they say online is not like talking to a mate down the pub?
I think there is, if you step back from freedom of speech for a moment, there is something fundamentally worrying going on here, which is what is the role of the state in defining conduct and ideas? If the state says, which is what it's doing at the moment, this and that is not offensive, as a corollary, as an opposite, it is also saying this is how much people are allowed to be sensitive and this is how much people are not allowed to be sensitive. Now, that is a very absurd world to go down. That's a very odd form of governance. Nobody in a liberal democratic society should want the state to define how sensitive they are. And I think that is one huge fundamental problem with all this. The other fundamental problem with all this is we seem to be living in a rather immoral time where this idea of forgiveness has seemed to have gone down the window. I say something to you, I must therefore, if the criminal law is involved, the state must vindicate me, must take revenge on my behalf, must lock me up. This idea that we forgive people who say stupid things, and that is a moral thing to do, and ignore them and allow them to exercise, the old-fashioned words are just words. Sticks and stones may break my bones. Words never harm me. That is gone. That is gone. And the third element is that we seem to be going in the direction of what very much what canon law used to do 400 years ago, which is sort of define the boundaries of what is what is sacred and what is not. Who is to define these sacred cows? Who is to say that over there is sacred and this isn't? Well, if we're going to do that, then we're going to give a state a huge amount of power to define not just what is offensive and how sensitive people should be, but surreptitiously define the forms of political debate. And that's where one sees huge issues. For example, if one is to talk about the treatment of women under Sharia law in the UK, you immediately are censored or controlled from putting the debate in a particular way. And that's going to undermine you campaigning for a particular issue. And that is the sort of long-term impact of this. So I would say, let's bring the state completely out of this. These are not boundaries that the state has ever legitimately empowered itself to do. And this is basically a system of bureaucracy.
What do you then do about other rights? Because we're all here mostly defending free speech, but we also respect the other rights in the Universal Declaration of Human Rights, right not to be discriminated against, right to privacy. So are you saying the state should have no role in any of those? Because we all have to think how to balance those rights as well.
I don't think these rights have to be balanced, they have to be prioritised. They're liberties. I don't mean rights in the absolute social sense. That's not something I believe in. I don't believe anybody has a right to anything very much. I think we have to earn rights. We have obligations to each other, but those obligations also go for tolerating and forgiving each other. That's also an important part of this, and that shouldn't be forgotten. I don't think it's the role of the state to decide what is acceptable speech and what isn't.
Let's hear from Edward Goodman, the chair of the Campaign Against Censorship. Edward, should the state be drawing up these guidelines, like you've heard from Abhijit saying that they shouldn't? Do you think they should?
No, I think this law should be repealed. The state should not be having anything to do with electronic communication. If an offence is committed, there's plenty of other laws, incitement to crime or incitement to racial hatred. People can be prosecuted for that, for anything, whether it's on electronic communication or in a newspaper or orally. So we don't need this special control by the state of electronic communication to prosecute and, if necessary, imprison anybody who sends a grossly offensive message. There shouldn't be that law. The general law should apply, as it does to all communication. So this section of the Communications Act 2003 needs to be repealed, not to have guidelines of who should be prosecuted and who should not be, because the very fact that you have this chill factor that you might be prosecuted for what's in your electronic message is a form of censorship. You just should obey the general law, not incite crime or conspiracy to commit a crime and so on.
Rob Lyons from the online magazine Spiked.
Well, I mean, I agree with much that's been said, that it really isn't the place of the state to do these things. And once you start into creating exceptions to the principle of free speech, then it's very much a thin end of the wedge, because then, if you say we shouldn't allow speech that is offensive in some way, then we open up the possibility of who defines what is offensive.
But shouldn't we prosecute serious wrongdoing?
Well, yeah, I mean that's true. I mean, so I think it was Edwards who just said, if you have some situation where we have people organising an armed robbery on Twitter, which would be the most stupid thing to do, then perhaps but then that would be conspiracy. It wouldn't be anything to do with a question of free speech. But even I mean, Kirsty mentioned incitement. I mean, I think you'd have to go a long way before I would accept something like incitement. So if somebody says something offensive like "let's kill all the Jews," I mean, I just don't think that should be regulated free speech. But I mean, it's deeply offensive, of course, but I don't think that should be regulated free speech, because at the end of the day, we also have to accept the principle that the person listening to the speech is capable of making a judgment for themselves about those things. I think in these circumstances, you're going to be handing control over these decisions to the state, and you're also assuming that people. In many cases, there is an assumption that people are automatons, and that when they hear something offensive, that they will accept it. So they hear racist comments, for example, that they will become racist because of hearing those racist comments. And I think that that's just a ridiculous assessment of what human beings are like.
I agree with most of that, but I'm a bit worried at the suggestion that we don't necessarily need these interim guidelines. It would be great to see the section of the Communications Act repealed. It would be great to also get rid of Section 5 of the Public Order Act, which is also being overused and misinterpreted by the police to police offence rather than anything that's actually criminal. But what we're faced with at the moment is people going to prison, being given community service orders, because both because of the law, but also because of an extraordinary interpretation of the law, where, I mean, only one of the few positive cases recently, at least in the outcome, Paul Chambers, so his quip about blowing at Robin Hood Airport was said by the judge, that was a joke, there is no case here. So let's get the interim guidelines. Let's hope that they at least push things in the right direction. I think the consultation on those guidelines is incredibly important because I think there's going to be an enormous input from everybody who cares about social media. That's very healthy. And then, yes, let's have the longer run campaign to change the law. But in a sense, I suppose I'm saying don't throw the baby out with the bathwater.
Now, Kirsty Hughes from Index on Censorship, you just said before that comments made online are kind of in the middle between being published in a newspaper and having a chat with a friend down the pub. I think it might be interesting for us now to listen to a clip from John Whittingdale, the chair of the Culture, Media and Sport Select Committee, speaking to the Voice of Russia earlier about his comments about where he thinks these comments lie.
The law which applies to social media online should be no different to the law which already applies to comments made in newspapers and other articles and published comments. There are already clear laws about defamation and about material which is likely to incite racial hatred, and those are the same tests which I think should apply online as they do offline.
Abhijit Pandya, chair of the Birkenhead Society, what are your thoughts about what you've just heard from Mr. Whittingdale?
I don't agree with what he's just said, and I don't agree with what Kirsty has just said. There seems to be I remember teaching law students that people love finding middle grounds and things. There should be a balance somewhere. We should at least listen to these guidelines and so on. I think you should go back to the root of the argument. Firstly, why should the state get involved? And the other point I want to make, following on from what's just been said, is that you've got to understand both libel, as it is today, and also the idea of incitement. Both of these things are rooted very, very much old-fashioned laws which would go back 200 years. Incitement was there at a time when literacy levels were really low. You know, we should be thinking about whether incitement should still stand today. For example, why should I not be responsible for my act? Why should somebody else who's whispered in my ear be responsible for that? You know, where should responsibility lie? That question in criminal theory is yet to be put out there in the journals, and that the idea is yet to be attacked. Similarly for libel, Britain is extraordinary. One of the few countries in the Western world that will pulp books, where you can pulp books because there's a libel in them. You can actually get an order from the High Court to stop something from being published. Now, this is extraordinary stuff in the 21st century for this to be still existing as a law. And I think that what we need is a review of where the role of the state lies. And of course, it's good for bureaucrats, it's good for NGOs, it's good for these people who are usurping taxpayers' money or money from donors to sort of publish papers and then review them and have these court cases, which again, public money is being spent. But actually, it's a bit of a OTO's exercise.
I think that's really a little bit outrageous, excuse me, to suggest that somehow you're more principled in defending free expression and an NGO, because we have to raise money, presumably you get paid a salary too, is somehow motivated to make fuss or provoke a consultation that's not necessary. And I wasn't actually saying we should find a consensus on the middle ground. I was saying we should take an opportunity to get away from where we are now and start to move in the right direction. And I think surely there is always going to be a question, whatever laws we have, good or bad, right or wrong, of how they're interpreted. And I thought on Sunday, when you saw Occupy protesters in St. Paul's Cathedral, it was fascinating to see, and at least on that one reassuring compared to Pussy Riot in Moscow, that the police took an awful long time, let them make their protest before they said, leave now or you'll be arrested.
I don't detract from my point at all. I think if your position was that these laws need to be repealed, then what follows from that is, why do you need guidelines? Why do you need to have this committee or input from people deciding where the boundaries of free speech are? If you're committed to having the state pull out of the boundaries of freedom of speech, that is where you stand. I mean, there may not be too much work there for people, barring just campaigning for that principle, but I think that is where the boundary needs to be drawn. Free speech is something extraordinarily special, and like any other liberty, it allows you to win back all your other liberties, as Mark Twain said. It is distinct, along with habeas corpus, or the right for your own body, and leaving the state out of your own bodily integrity. Those are the two most important liberties that define.
But these guidelines do do have a clear purpose. They're going to be drawn up not only for prosecutors to know where to draw the bar, but also for Twitter users, so they know where they stand within the law as well.
No, the problem with the guidelines is they're under an existing framework under the European Convention of Human Rights, Article 10, where the state can define in its own interest where the boundaries are under the doctrine of proportionality, where the boundaries of free speech lie. And this is basically simply another stamp on an existingly flawed framework which allows the state to define the boundaries of speech. And it's just a fake refinement of an erroneous principle. You need to go back to the basic principle that freedom of speech is absolute.
Excuse me, but where does that principle come from? Because from what you're saying, as far as I understand it, you want the European Convention on Human Rights and the court to be closed down, whereas for us, we wouldn't want that to happen, because that's where our right to freedom of expression comes from, and as from the Universal Declaration.
Let's bring in Edward Goodman. We haven't heard from him for a while.
Nonsense.
Chair of the Campaign Against Censorship. What are your thoughts about what you just heard from Kirsty Hughes and Abhijit Pandya?
Well, I agree, but we do need legislation, because the problem is, if you have this Communications Act, it's the duty of the Crown Prosecution Service to prosecute people. So whatever guidelines there are, people will get prosecuted for sending offensive Twitters. The only way to get rid of it is to amend the Act, and the Birkenhead Group chairman is right. Basically, we need a Freedom of Information Act protecting freedom of information, freedom of expression in this country, because you have all these little laws which are restricting it. So this is the problem. We've got the Communications Act, which says it's a criminal offence, imprisonable, to send a grossly offensive Twitter, and that is the root of the problem. So whatever the guidelines are, it will mean people are being prosecuted for what they send on Twitter, which would not otherwise be illegal.
You're listening to The Voice of Russia in London. I'm Daniel Cinna with a discussion on how social networks should be policed. Joining me is Kirsty Hughes, Chief Executive of Index on Censorship. Rob Lyons is the Deputy Editor of the online magazine Spiked. Abhijit Pandya is Chairman of the Birkenhead Society, a free speech group. And joining us on the phone is Edward Goodman, a lawyer and Chair of the Campaign Against Censorship. So, unlike Abhijit Pandya, you believe there is a purpose, there is a role for these guidelines?
Well, interim, liberalise it, but the root of the problem is that still people will still be prosecuted for sending offensive Twitters, whatever the guidelines are. The guidelines are not going to say that the law is not going to be applied. They hopefully will say that it's applied with only the extreme cases, but people will still be prosecuted and, if necessary, in prison for the Twitters they send.
Can I make a brief point on that? Because, I mean, the judge who cleared Paul Chambers of his joke about blowing up an airport said satirical, iconoclastic, rude, unpopular opinion and so on should not be interfered with by the Communications Act. Now, if we could get that into the guidelines, then that would be a big step forward in a short time while working on the Act.
Why is there a judge? Why is there a judge even making a ruling on that? It shouldn't be the case. I mean, I would be very clear that actually, I mean, I think Kirsty's very, very optimistic about the European Convention. I would personally like to see it scrapped. I think that actually the European Court on Human Rights is actually tends to be a barrier to freedom as much as a supporter of freedom now. And I'd certainly like to see the end of the libel laws as well. You know, I think I think whenever you see a situation like this, whether we're talking about regulating free speech and whatever, actually, even if you think something like, for example, somebody in a libel situation having some kind of right to reply, as soon as you get the courts involved, you think actually that's worse than dealing with these matters through the court of public opinion. Anybody who uses a social network should understand that what they're doing is public, even if they think it's private. So in the Paul Chambers case in particular, that was accidentally public because he was trying to send a direct message, but nonetheless, it is public speech, but it's at the end of the day, it's not for judges, it's not for politicians, it's for anybody else to determine what the limits are of free speech. We need to establish that as a principle broadly in society, that the judges don't get involved with that.
Would you get rid of the Universal Declaration of Human Rights as well? And in that case, how would you and Abhijit get it established as a principle?
The answer to this question is that in order to protect liberty today effectively and to demarcate the boundary of where the respective roles of the state are, is that Britain needs to move towards thinking about having a written constitution American style. Not these kind of rights declarations or European Convention of Human Rights, which empower the state to define the boundaries of this right. If you look at the European Convention of Human Rights, it says you have the right to free speech, but the state can take that away in the interest of national security, public health, public morals, and so on. Well, that is not a charter for liberty. That is a charter empowering the state to define the boundaries of liberty and to take them away. And that is where freedom of speech is lost. Freedom of speech cannot be left to a court, a government body, or an international organisation to be defined. It has to be left for society to get on with people who wish to say whatever they wish to say, whether it's offensive or not.
Kirsty, from what you've just heard from Abhijit, Twitter, with its free speech policy, meaning it doesn't interfere with any disputes or whatever, is doing the right thing.
I agree with a lot of what Abhijit has just said. It's the derogations is the issue, and how broadly or narrowly they are interpreted, and we're always pushing back for a very narrow interpretation. And I think what we want to see with Twitter or Facebook is we don't want to see Twitter or Facebook stepping in and doing moderation. It will completely transform what's possible because of the apart from anything else, the bulk of the material there. So we don't want them to have to behave like you as a broadcaster or a newspaper as a publisher. But you will have existing laws of the land, and they will get applied. So then you have to decide which of those are sensible and which of those you most have a problem with. But I think we've got to get people to understand that there is no right not to be offended, and that a lot of this is about editing, self-editing, your own choice of where you go, how you run your own social media life.
Edward Goodman from the Campaign Against Censorship. We heard in the case of Paul Chambers, the man found guilty of sending a menacing tweet about an airport, and his conviction was then overturned, that the judge focused there on that the message was sent in jest, that they were looking at the motive. It seems that the DPP are going to be bringing in these guidelines. Do you think a focus on motive is the right way forward?
Well, yes, we'll see if that's in the guidelines. I don't think it will be. Well, the problem with the guidelines is that they will provide a specific framework telling people whether they're likely to be prosecuted, and then that will provoke the Twitter authorities into trying to prevent anything which might breach the guidelines. So they will have the chill factor effect of promoting self-censorship. So it will destroy freedom of expression on Twitter.
Rob Lyons from Spiked, is that where the line should be drawn, looking into someone's motivation?
I don't care, for example, if somebody says something horrible and offensive and racist, because we should be allowed to judge that statement for ourselves. The state needs to stay out of these things so that we can have the free and fullest possible process.
What if someone on their Twitter page threatened that they were really going to blow up an airline, or they were really going to blow up an airport? How would you deal with that comment?
Well, I just think it would be very difficult to take that seriously. But the point is, that in itself shouldn't be a criminal matter.
This is a serious threat from a terrorist who is going to go and blow up an airport. What would you do?
Obviously, if X says, I'm going down to Heathrow now to blow up a plane, then somebody at Heathrow might want to look out and see if X turns up. But otherwise, most of us would recognise that 99.99% of people who say those things online do not mean them, are not serious about it, and therefore regulating comments online on the basis that one of those people might be in some way serious is a bit ridiculous, and it's not very practical.
Kirsty Hughes, how would you deal with that comment?
I think we agree on most of this thing. I think one of the interesting points where we have disagreed is about incitement to violence, and whether it's the terrorist example you've just given us, or whether it's a group of young men maybe in a city encouraging an attack on someone else or on somebody of a different colour or ethnicity, then I think there are issues around violence where you actually want the law to step in.
Well, unfortunately, we've run out of time for today's discussion. Thank you to all of my guests: Kirsty Hughes, Chief Executive of Index on Censorship; Rob Lyons, Deputy Editor of the online magazine Spiked; Abhijit Pandya, Chairman of the Birkenhead Society; and joining us on the phone, Edward Goodman, a lawyer and Chair of the Campaign Against Censorship.